today. We are really honored, sir, by your presence, and thank you very much for accepting to be with us today.
Thank
We
you, sir.
hope you will come to our library, you will visit us often and guide us also in this field. Today, we are having this lecture under two endowments, namely Navalpakkam, Mimisal, Narasimha Tatacharya, as well as Justice Rajagopala Ayyangar. Both were exemplary scholars in their own fields. And this Tatacharya was, as we call them, Chatushastra Parangata. He was an expert in 4 Shastras, namely Vedanta, Vyakarana, Mimamsa, and Nyaya. And he was in the 19th century, and he was highly respected for his depth of knowledge. And he has trained so many scholars in the most traditional way, and he has guided many people. He has been honored by many of the royal personages those days, like Pudukota, Trivandrum, Cochin, and other places. And he has done a very great service to the cause of traditional Sanskrit knowledge. He is the great-grandfather of Sri N. Raghunathan, former Chief Secretary of Maharashtra, former Secretary of India, and in his name one endowment was instituted by Sri Raghunathan. And the other great legal luminary was Justice Rajagopala Ayyangar, who was very close to Alladi Krishnaswamy Iyer and all others during that time. And he was the judge of Madras High Court. He had a wonderful distinction of being appointed as a judge to the Supreme Court after his retirement from Madras High Court. It's a rare honor. And he was an expert in Hindu law, in constitution law, in civil and criminal law, and so many other aspects. And he was also the chairman of Press Trust of India, and he had done a lot of service in formulating many of the constitution and also many acts. And he had helped so many great men like Right Honorable V.S. Srinivas Sastry, who have acknowledged his assistance in their career. And he was the father-in-law of Sri N. Raghunathan. And we are indeed privileged that another legal luminary has come forward. He has accepted to give a lecture on jurisprudence to us today. We will be anxiously awaiting your lecture, sir. And we would like to hear more and more from you in future also. And the first lecture under this endowment was given by one of the greatest legal luminaries, Sri K. Parashara, very respectable person. And of course, Vedantam Srinivasan, another senior advocate, and one of the greatest Sanskrit scholars, Mimamsa and Jurisprudence. The lecture's topic was given by Goda Sastrigal. And of course, we had Dr. C.L. Ramakrishnan, former Director General of Police, as well as Director of Vigilance and Anti-Corruption, Government of Tamil Nadu, and a person with impeccable police record. Like that, we have heard very illustrious scholars, and Justice Ramasubramaniam also had given one lecture under this endowment. And today, Justice Mahadevan has come to us to give a talk. And the endowment maker is Sri N. Raghunathan, who was from Tamil Nadu only. And he was the Secretary to Government of India and later Chief Secretary to Government of Maharashtra. And he was so close to all of us in our institute, and he knew all our family members also. He and his wife, Shyamala Mami, had taken so much of pain to stand with us literally. They used to stand for hours together in our library, in rearranging the books in our library without expecting anything in return. And Sri Raghunathan's book on administration has been published by the Bharatiya Vidya Bhavan, and it is a Bible for many of the administrators, and he has also translated, following the footsteps of his great-grandfather, Rahasya Traya Sara of Sri Vedanta Desika, which the Sanskrit Academy has published. And he gave this endowment in memory of his father-in-law as well as his great-grandfather. And today, we have got Justice Mahadevan, who is no stranger to many of us who are following or reading the newspapers daily, and at least many of us read our Hindu or Indian Express or Times of India and or Tamil newspapers, and often we find the name of Justice Mahadevan. We are indeed very happy that he has found time to be with us today, and also he is an expert in tax and also criminal law, civil law, writ, so many things. And he has presented more than 11,000 cases in our Madras High Court, and more than 500 of them have been recorded in the Madras Law Journal, which is really a creditable record. And during his college days, or perhaps school days onwards, he has been associated with literary activities, and I think he has followed the footsteps of his father, who is a well-known literary figure, and his mother also. So he has got that in his gene, and he has kept up that fire of learning in the field of literature as well as law. And we are really proud of you, sir, that such great people are adorning our High Court and continuing the tradition. And also, we are proud to be associated with you. And being impertinent, I would like to say that most of the judges who came to us have been elevated in their position, like Chandrachud, Chandurkar, and also we have got Justice Ramasubramaniam, and before that Balakrishnan. So many people, they have been elevated. And recently we had another great person, Vice Chancellor of MGR University, Medical University, Dr. Sudha Seshayan. After she delivered the lecture, she had been conferred with the FRCS. So we pray that our Justice Mahadevan sir will also be blessed with more and more accolades by God's grace. He will scale new heights. Already he is a well-known person, but he will be known internationally. And with this prayer, I welcome Justice Mahadevan amidst us today, and I request him to give this lecture on jurisprudence. And we are eagerly awaiting for your lecture, sir. Once again, I thank you for joining us today, and I welcome all of you for this endowment lecture today. Over to Justice Mahadevan, sir. Namaskaram.
Namaskaram. Thank you, sir. Am I clear now? Voice?
You are clear, sir. You are clear.
Thank you. Respected Dr. Sita Suntaram, the Secretary, Kupusami Sastri Research Institute, Mylapore. Honorable Justice Prabhashri Devan, Sanskrit Kandan sir, and other eminent personalities and scholars here online. Good evening to you all. I am happy and delighted to be with you all today here in this internationally well-known institute in the field of Sanskrit and Indological studies, started by the great Sri V. Krishnaswamy Iyer. It is a honor to deliver a lecture under the Justice N. Rajagopala Ayyangar Endowment, and I thank Dr. Sita Suntaram and Honorable Justice Prabhashri Devan for this excellent opportunity. I was actually invited to deliver this lecture on Sanskrit literature touching jurisprudence. But considering the prevailing sociological developments and the issues invited the attentions of the society at large, Based on the recent judgments of the Honorable Supreme Court, I opted to deliver this lecture on the importance of jurisprudence in an evolving society, touching the role of legal positivism in shaping progressive judicial thinking in India. This is based on three important cases. If law is a language, jurisprudence is its grammar, says a famous quote. Jurisprudence or legal theory is a theoretical study of law. Scholars of jurisprudence seek to explain the nature of law in its most general form and provide a deeper understanding of legal reasoning and analogy, the legal systems, legal institutions, and the role of law in society. Jurisprudence is a study of law which penetrates to the theory and philosophy of law as a discipline. Jurisprudence is an integral part of law which helps a person to understand law in a logical and philosophical manner. I can say it deals about the relationship of law with other social sciences, society, man, and nature. Jurisprudence mainly comprises of research and method to construct and clarify the basic concepts of law. According to ancient Indian jurisprudence, it is defined in various Dharma Shastra texts, starting with the Dharma Sutra of Bodhayana. Similarly, in ancient China, the Taoism, Confucians, and legalists all had competing theories of jurisprudence. In an article by Virendra Kumar, Associate Professor, Nalsar University, I quote, Vedic literature states that the welfare of the people must be the central concern of the king or the leader of the society, whose acts should be directed for the welfare of the people. Once the concept of the state has evolved the development of law, the legal theory naturally follows. The Hindu system of law has been so rich in principles, precedents, and concepts that even the most advanced legal systems of modern times are unable to surpass it. The eminent Indian jurist K.P. Jaiswal makes the position clear beyond doubt. He says, all attempts to reform the society are bound to fail if they neglect the individual, the basic unit of society. Therefore, the ancient Indian philosophers, jurists or reformers who had fully grasped the preaching of the scriptures and had worked them out in practical life, always stressed that the first step for a coordinated, harmonious society is that ambiguities and conflicts must be eliminated from the minds of the individual. Hence, every reform must start from the individual. There is a moral vacuum. The author of the code is not an ordinary individual possessing worldly knowledge alone. He seems certainly to have comprehended the ultimate truth, the truth of the Spirit, and it is in the light of this truth that he wants to reshape the actual life of the people. I unquote. Social welfare element in the ancient Indian jurisprudence is the concern of Dharma. Therefore, Dharma had from the very beginning a social dimension in ancient Indian scriptures. Legislators like kings and the philosophers who propounded the law codes were seriously concerned with the welfare of the members of the society. I can quote here a sloha related to Manu. Krudethu manava progdas trethayam yaknya valkya twabare sankalikita kalo parashara Sramruda. In Tamil, மனுவினுடைய சட்ட நூல் கிருதயுகத்துக்கும் யாக்ஞவல்கியரின் நூல் திரேதாயுகத்துக்கும் சங்க லிகிதர் எழுதிய நூல்கள் துவாபர யுகத்துக்கும் பராசர நூல் கலியுகத்துக்குமானது. Manu describes Shrudistu Vyatho Vijñeyo Dharmasastram Tvai Simruti Re Sarvar Deshvamimasye Dapyam Dharmohi Nirbhav. Means Vedame Shruti எனப்படுகிறது, தர்ம சாஸ்திரங்களே ஸ்மிருதி எனப்படும். இவைகளை சங்கேதித்தல் என்பது ஒப்பானது ஆகாது. கவனமாக ஆராயப்பட வேண்டியவை இவைகள் அனைத்துமே. ஏனெனில் இவற்றில் இருந்துதான் தர்மம் என்பதே தோன்றியது. I unquote. It is said almost by all philosophers that all Hindu law originated from Vedas, also called Shruti. Some of the scholars say the Hindu law really emanated from books called the Smritis, Manusmriti, Yajnavalkya Smriti, and the Smritis of Vishnu, Narada, Parashara, Apastamba, Vashishta, Gautama, etc. These Smritis, written by certain Sanskrit scholars in ancient times who had specialized in law also. Vitakshara on the Yajnavalkya Smriti, the contemporary of Jimutbha, who wrote a book called the Dayabaha, a digest of several Smritis. Nanda Pandita, whose commentary Datak Mimamsa deals specifically with the law of adoption. Commentaries were then written on these commentaries, which is a commentary on the Mitakshara principles. The Hindu law, as we all know, got divided into two branches, the Mitakshara as well as Dayabaha. When we say Mitakshara is a commentary on the Yajnavalkya Smriti, in Yajnavalkya Smriti, the first chapter, Archaka, deals with religion and morality. The second chapter deals with Vyavahara, deals with law, and the third chapter, Prayashchit, deals with penance. Narada and Brihaspati, who in their Smritis confine themselves entirely to law, particularly civil law. In Sanskrit literature, the field of law and jurisprudence was enhanced by authorities like Manu, Yajnavalkya, Prasara, Narada, Kautilya, etc. by their works. At the same time, the grammatical tradition was also developed through different schools of thoughts like Paninian thought and non-Paninian, and touched its glory by 18 different Smritis, namely Atri, Vishnu, Harita, etc., numbering 18. Though it is said the modern jurisprudence began in the 18th century, jurisprudence, which is also known as legal theory, can be said to have existed as early as civilization itself. This is because the first understanding of law or established of any kind of order in society sprang from fundamental and natural notions of right and wrong. It is apparent that other institutions of society, whether it is a system of government or the judicial systems, are all creatures of jurisprudence. Man was born with certain natural needs and desires, the foremost of them being the desire to live and to procreate, which are counted by Aquinas, Thomas Aquinas, among those basic human values on which all other human values are based. The English word jurisprudence, according to various philosophers, is derived from the Latin word, is the genitive form of jus, pronounced jus, meaning law and prudentia. Prudence, which could also be read as discretion, foresight, forethought, or circumspection. It refers to the exercise of good judgment, common sense, and caution, especially in the conduct of practical matters. The first word appeared in written English in 1628, at a time when the word prudence meant knowledge of or skill in a matter. It may have entered English via French jurisprudence, which appeared earlier. Some of the professors define jurisprudence as the science of law or the science of the first principles of civil law. And some say, like R.W. and Dias, study of jurisprudence provides an opportunity to the lawyers to bring the theory and life into focus, or for it concerns human thoughts in relation to social existence. According to Pound, one of the greatest philosophers, jurisprudence is closely related to ethics, economics, politics, and sociology. According to Friedman, the greatest contribution of the natural law theory to the legal system is its ideology of a universal order governing all men and protect their rights of individuals. Henceforth, they defined the theories of law. There are various theories of law in jurisprudence. The first of them being natural law, and the others being analytical jurisprudence and normative jurisprudence broadly. The other schools include the historical, sociological, and most recently, the contemporary school of jurisprudence, also noteworthy in mentioning. Natural law, the earliest understanding of jurisprudence, was derived from the first principles of natural law. Aristotle, who is known as the father of natural law, was of the idea of golden mean. His treatment of political justice derives from his discussion of justice as a moral virtue, derived as the mean between opposing voices. He actually promotes that the term justice actually refers to two different but related ideas. That is, general justice and particular justice. When a person's action towards others are completely virtuous in all matters, Aristotle called them just in the sense of general justice. Analytical jurisprudence rejects natural laws, fusing of what law is and what ought to be. It exposes the use of neutral point of view and descriptive language and differing aspects of legal systems. It encompasses such theories of jurisprudence as legal positivism and legal realism. Normative jurisprudence is concerned with evaluative theories of law. It deals with what the goal or purpose of law is, or what moral or political theories provide a foundation for the law. It not only addresses the question, what is law actually, but also tries to determine what the proper function of law should be, or what sort of act should be the subject to legal sanctions, and what sort of punishment should be permitted. While natural law broadly be defined as law which is based on first principles and on the laws of physical science and state of natural law, positive law or clarificatory law can be understood as law which is the product of human activity or human volition. David Hume, in his treatise of human nature, argues that analyzing and clarifying the way the world is most be treated as a strictly separate question from normative and evaluative questions of what ought to be done. On these lines, sociology and jurisprudence are getting mingled. The sociological approach is much more concerned in the working of law, and it means the law can be adjusted as per social needs. Economics and jurisprudence also play, that is, normative jurisprudence deals the stable economic allocation of resources in a society. History and jurisprudence mainly forms a significant part of legal history, And the law has been around for centuries. And as we know, jurisprudence is a study of law. Ethics and jurisprudence also play a pivotal role, which talk about the fact that how the law should be in an ideal state. Politics and jurisprudence state that the laws made for people shall be unbiased. There are various theories like natural law, which aims to find a common moral ground for different cultures and religions and did not originate from some political authority or any legislature. Natural law can be applied anywhere in the world. Imperative law directly opposes natural law, which is much more focused on realism when it is compared to natural law. The theories of legal realism and imperative law see the law as a type of command. But in the case of the theory of legal realism, it sees the law as a type of command that must be given by the legislature, and for legal realism, the sovereign is the Supreme Court. Law of obligations has been derived from Roman law. Normally, the philosophers say, in its legal sense. Law of obligation can be said to be a relationship of legal necessity in its original sense and relates to being proprietary rights in its own sense. These schools, philosophical schools, and etc., focuses much more in the theory of natural law, which aim to find out the reason why a law is enacted and the effects of such a law in our society. Analytical school is focusing on the theory of imperative law and believes that law should be codified and governed by the state for the benefit of the people. The historical school normally believes that law is a consequence of years of growth, the source of law, the customs, the religious philosophies and social rules. Realistic school, on the other hand, is teaching of thoughts focused on the actions of the court and thus logical assumptions from the general law. Similarly, sociological school concentrated more on the functions of law, which is based on various thoughts of jurists and connects law with society according to the needs. With this, I can focus this page on legal positivism theory, its evaluation and development in the society. Today, the focus is to understand the concept of legal positivism, which is as a part of analytical jurisprudence, as stated, and to understand how it has and continues to shape the progressive judicial thinking in India, and how, therefore, this class of jurisprudence plays a pivotal role in an evolving society nurtured by the positive changes, which may be even shocking. What is the meaning for legal positivism? In simple words, legal positivism is the separation of law from morality. This is a very vital subject to be discussed in an elaborate manner. While deciding the validity of the law, the courts must confine itself to the constitutional provisions and not look at whether the law would be morally acceptable from the social or public perspective. This is because public opinion is usually influenced by our moral values, and our moral values in turn are a direct result of social conditioning. From childhood to when a person starts thinking independently, every person is taught how to think on certain issues, and our mind is conditioned in such a way when we are brought up in a particular social setup that our opinions are usually the result of the larger public opinion on many issues in society. The law, however, cannot go strictly by public opinion, which is based on majoritarian social thinking on an issue based on general morality. This is the further importance because law should always lead society into its progress and steer the way forward. Public opinion and moral values in society change slowly. What may be considered immoral today may be considered moral acceptable after 2 or 3 decades. See, now the media is covering various aspects with regard to live-in relationship, were once a complete taboo, but today society has accepted it to some extent. However, even during the time when society had completely frowned upon the practice, they were held to be legally valid and considered legal for maintenance and prevention of domestic violence. Therefore, even in the practice is considered not morally acceptable, in the majority view of the public, the law still upholds the practice if it is in tune with the larger constitutional goals of individual liberty and private rights of citizens. This is in essence is legal positivism. Legal positivism is of the view that the content of law is not dependent on or constrained by morality. See, this has created various avenues for debates. Within the legal positivism, theorists argue that law contents is a product of social facts, but theorists disagree whether laws validly can be explained by incorporating moral values. Legal positivists who argue against the incorporation of moral values to explain law validly are labeled exclusive or hard legal positivists. One of the professors, Joseph Ross, legal positivism, according to him, is an example of exclusive legal positivism. Legal positivists who argue that law's validity can be explained by incorporating moral values are labeled inclusive or soft legal positivists. Before going into the Indian application of the theory of legal positivism, let us look at something which is developed in recent times or from the old theories. I can refer Professor Jeremy Bentham and his student John Austin viewed law as commands backed by sanctions for non-compliance. Austin's answer to what is law was that law is a command of the sovereign backed by threat of sanction for disobedience. I unquote. This theory was, however, criticized by Professor Hart because, according to him, the command theory failed to account for individuals who complied with law even without the threat of sanction. Moving forward to the 20th century, Hans Kelsen, who was one of the prominent jurists and highly influential in Europe and Latin America, propounded his pure theory of law. According to the pure theory of law, the notion of basic norms or hypothetical norm presupposed by the jurist, from which all other norms in the hierarchy of the legal system, beginning with the constitutional law, as understood to derive their authority from. The most influential legal positivist of the 20th century was Professor Hart, a professor of jurisprudence at the Oxford University. He argued the law should be understood as a system of social rules. In his book, The Concept of Law, Hart rejected Kelsen's view that sanctions were essential to law and that the normative social phenomenon like law cannot be grounded in a non-normative social facts. Here, we need to touch upon the legal realism, which is the view that the theory of law should be descriptive and account for the reasons why judges decide cases as they do. The essential tenet of legal realism is that all laws are made by humans and thus should account for reasons beside legal rules that lead to a legal decision. One particular Privy Purses case seen the broad overview of the genesis of the theory of legal positivism. The Supreme Court has applied this theory to uphold laws passed by legislature uphold fundamental rights and other constitutional guarantees, and examine criminal law provisions without reference to social morality, while testing laws and upholding rights on the anvil of constitutional morality. The recent times where the Constitutional Bench of the Supreme Court has in each of these cases applied the concept of constitutional morality while keeping social morality out of the debate in order to determine the validity of the provisions and upholding private rights of citizens in accordance with the guarantees made under the Constitution. The Supreme Court applied the theory of legal positivism while testing the constitutional validity of the 26th Amendment of the Constitution, which abolished the privy purses, one of the first cases when a constitutional bench applied this theory. The Supreme Court relied upon the positivist theory of Professor Hart, while stating that Hart excluded morality from the concept of law. May be shocking. Now we shall examine the recent cases where the legal positivist theory has been given an extended meaning and the theory as such has been applied to suit the nuances of Indian constitutional scenario in a way as to nudge the judicial thinking in India to be more progressive and in tandem with the constitutional principles. In the case of Navdeep Singh Johar, which dealt in detail with morality can be a ground on which the private rights of citizens as well as the right to privacy can be denied in the matters touching Section 377 IPC. The question before the Supreme Court was whether the criminalization between two consenting adults of the same gender should be tested on the anvil of social morality, leaning on majoritarian perception, or whether the issue had to be decided in the backdrop of constitutional morality. When dealing with the issue, the Supreme Court referred to the concepts and theories of positivists. Lord Devlin's theory was taken into consideration, who delivered a lecture which was an attack against the report of the Wolf-Henton Committee, which had recommended the decriminalization of sodomy laws in England. That report, according to that report, it is not the purpose of law to intervene in the private lives of citizens or to seek to enforce any particular pattern of behavior. The professor perpetuated by the report and the line of reasoning framed several questions on the issue of criminal law and morality. One of the questions: has society the right to pass judgments on all matters of morals? The right of the society to pass judgments. If the society has the right to pass judgments, has it also the right to use the weapon of law to enforce it? Professor Devlin believed that society depends upon a common morality for its stability and existence. On the basis of this belief, it was answered that society has the right to pass judgments on all matters of morality and also the right to use law to enforce such morality. Counting his theory, Hart argued that society is not held together by a common morality. For after all, it is not a hive mind or a monolith governed by a singular set of morals and principles. Professor Hart, in one particular occasion, said that law is morally relevant, but not morally conclusive. In this way, he avoided the generalization that the law must be severely quarantined from morality, but still made it clear that law like Section 377, which imposed a majoritarian view of right and wrong upon a minority in order to protect social cohesion, are jurisprudentially and democratically impermissible. J.S. Mill also made a strong argument on those lines against popular morality being codified into laws. He argued that disgust cannot be classified as harm, and those who consider as an injury to themselves any conduct which they have a distance or distaste for, cannot dictate the actions of others merely because such actions contradict their own beliefs or views. Mill believed that society is not the right judge when dealing with the question of when to interfere in conduct that is purely personal, and that when society does interfere, the odds are that it interferes wrongly and in the wrong place. Although Section 377 prima facie appears to criminalize certain acts or conducts, it creates a class of criminals consisting of individuals. It also typecast LGBTQ individuals as offenders, categorizing their consensual conduct on par with offenses related to Section 377. Not only criminalizes acts which should not constitute crime, but also stigmatizes and condemns individuals in society. The Supreme Court, after delivering in great detail on the opinions expressed by legal positivists, came to the conclusion that the court is aware of the perils of following morality to dictate the terms of criminal law. Therefore, the Supreme Court was inclined to observe that it is constitutional morality which should be the driving factor in determining the validity of Section 377. The Supreme Court also held the conception of constitutional morality is different from that of public or societal morality. Under a regime of public morality, the conduct of society is determined by popular perceptions existent in society. Constitutional morality determines the mental attitude towards individuals and issues by the text and spirit of the Constitution, which requires that the rights of an individual ought not to be prejudiced by popular notions of society. It assumes that citizens would respect the vision of the framers of the Constitution and would conduct themselves in a way which furthers that vision. Constitutional morality reflects that the idea of justice is an overriding factor in the struggle for existence over any other notion of social acceptance. Constitutional morality leans towards making Indian democracy vibrant by infusing a spirit of brotherhood amongst the heterogeneous population belonging to different classes, races, religions, cultures, caste, and sections. Constitutional morality cannot, however, be nurtured unless, as recognized by the preamble, there exists fraternity which assures and maintains the dignity of each individual. Various theories on constitutional morality, which requires, according to them, that all these citizens need to have a closer look at, understand and imbibe the broad values of the Constitution, which are based on liberty, equality, and fraternity. Constitutional morality is thus the guiding spirit to achieve the transformation which above all the Constitution seeks to achieve. Highlighting the significance of individuals' rights in social transformation, the views of the Supreme Court can be maybe like constitutional morality cannot be martyred at the altar of social morality, and it is only constitutional morality that can be allowed to penetrate into the rule of law. The veil of social morality cannot be used to violate fundamental rights of even a single individual. For the foundation of constitutional morality rests upon the recognition of diversity that pervades the society. Similarly, in the case of Sabarimala Ayyappan Temple, the Supreme Court was dealing with the constitutional validity of the rule banning the entry of women between the ages 10 to 50 years in the temple. In this case, the Constitutional bench was dealing with and interpreting the scope of fundamental rights under Article 25 and 26 of the Constitution, and specifically deciding whether an exclusionary practice based on a biological factor which is exclusive to the female gender is violative of Article 14 and 15(3) of the Constitution of India and not protected by morality as used in Articles 25 and 26 of the Constitution. In this case, not only did the Supreme Court examine whether morality as a ground can be used to test the validity of legal provisions in the general sense, but also whether morality is to be interpreted as used in the social sense to protect such exclusionary practices on the term morality as used in Article 25 as well as 26 of the Constitution as an exception to the fundamental right is only to be read as constitutional morality. This case touched a high point in the interpretation and application of the theory of legal positivism and the interpretation given by the Supreme Court to the concept of morality, even when specifically used as an exception to fundamental right, to mean only constitutional morality. As such, this case breaks new ground in transformative constitutionalism. The Supreme Court in this case held morality occurring in Article 25(1) of the Constitution cannot be viewed with a narrow lens so as to confine the sphere of definition of morality to what an individual, a section or religious section may perceive the term to mean. When there is a violation of the fundamental rights, the term morality naturally implies constitutional morality, and any view that is ultimately taken by the constitutional courts must be in conformity with the principles and basic tenets of the concept of this constitutional morality defined in theories of jurisprudence gets support from the Constitution. The Supreme Court went on to state that having said so, the notions of public order, morality, and health cannot be used as a colorable device to restrict the freedom to freely practice religion and discriminate against women of the age group of so-and-so by denying them their legal right to enter and offer their prayers at the Sabrimala temple for the simple reason that public morality must yield to constitutional morality. The term morality occurring in Article 25(1) of the Constitution cannot be viewed very simply with a narrow lens so as to confine the sphere of definition. Similarly, while the third case, while dealing with Section 497 IPC, criminalizing certain acts and dealing with the specific provisions which criminalizes the act of a man with a other person, while not criminalizing the same act if consent is given to the act by the other person, the Supreme Court was dealing with a question as to whether morality by itself can be a ground for criminalizing an act which is otherwise something that falls within the purview of the private life of citizens without the same being harmful to the society as a whole or having a color of criminal act in the real sense of the term. In this case, the Supreme Court held that creation of a just, egalitarian society is a process. It often involves the questioning and obliteration of parodical social modes which are antithetical to constitutional morality. The case at the hands enjoins this constitutional court to make an inquiry into the insidious penetration of patriarchal values in the legal order and its role in perpetuating gender injustices. Hence, the Supreme Court was able to find that a woman's purity and a man's marital entitlement, exclusive possession may be reflective of the antiquated social and sexual modes of the 19th century, but they cannot be recognized as being so today. It is not the common morality of the state at any time in history, but rather constitutional morality which must guide the law. In any democracy, constitutional morality requires the assurance of certain rights that are indispensable for the free, equal, and dignified existence of all members of the society. A commitment of constitutional morality requires us to enforce the constitutional guarantees of equality before law, non-discrimination on account of sex, caste, and dignity. The Supreme Court ultimately analyzed the appropriateness and effectiveness of criminal punishments in curbing these offences. Addressing the question of whether such offences should be regulated, the court stated that modern criminal law dictated that the state should seek to interfere in an act that is not socially harmful or otherwise the legal interest simply because it is repugnant to morality. By these three cases, an analysis of the above, the constitutional benches of the Supreme Court would make it amply clear that the theory of legal positivism has been employed in a way as to further as well as nurture the progressive ideas embodied in our transformative constitution and to interpret laws as well as to the test of their constitutional validity in such a way as to give precedence to the concept of constitutional morality rather than the perception of social morality through a majoritarian lens. These examples will show that the theories of jurisprudence are not abstract concepts to be read by law or by the students and to be forgotten as lawyers and judges, but to keep them alive and employ them in a way as to suit the needs of our society and within the context of the constitutional principles, with the goals of making our society more progressive, so as to achieve the emancipation and empowerment of all sections of society, including the women and the marginalized and those vulnerable to discrimination based on singular or multiple factors. If viewed from a broader angle, the goal of any society would be the merging of social as well as constitutional morality at one point of time. Until then, it is the duty of the courts to make sure that constitutional morality steers our society to a progressive future and that society is not bogged down by regressive practices encouraged by majoritarian perceptions of social morality. With this, I think I can conclude this speech related to jurisprudence, which touches the positivism, which is the main aspect as well as important charters dealt with by the Honorable Supreme Court. Thank you for this extraordinary and excellent opportunity to be with you all to deliver my speech on jurisprudence. Thank you very much.
Thank you, sir. It is really an extraordinary meeting. Are you able to hear me?
Yeah, I hear you, ma'am. How are you?
Yeah. It's really very, very interesting. Though we people have been dealing with the ancient texts, and you are bringing out the new modern outlook on the same law.
Yes.
The way you are putting it is entirely different from how we have read. But the facts that you have placed are the same. The way in which the present day legal jurisprudence deals with it is the same as what the ancients have done. And Kautilya would have approved of what you said as constitutional morality. Yes. When all the other legal luminaries like Manu, Yagnivalkya and others do have societal morality as part of their objective,
yes,
it is Kautilya who for the first time have brought the constitutional morality, and he does it without any qualm for anything.
yes,
He is very clear about this.
yes,
He is very practical. At the same time, he does have the ethical and moral values in his mind also, which are very, very very, very carefully penned by him when he wrote the laws.
Yes.
Really beautiful wording of the rules by Kautilya. One has to go through it with the commentaries and other things to understand really what he meant. But it is really what you call as constitutional morality that he had kept in his mind when he made his Arthashastra.
Yes.
Fantastic work. At the same time, my question is, would you throw away societal law, societal morality in a sweep of your hand? You can't do that.
No, it cannot be done. That is one. But the Supreme Court decisions, which I referred now, all the three cases.
Yes.
What I referred, what I spoke here, all based on the observations made by the Honorable Supreme Court in all these cases.
Yes, the first case was about, for the first 15 minutes, you had traced the history of Indian jurisprudence and the Western jurisprudence.
We are having an extraordinary traditional values, our system, our scriptures, all.
Yes.
But the present scenario, I wanted to project the present scenario, which was dealt by the Supreme Court in three different cases touching 377, 497, as well as the Sabarimala case.
Yes.
In all these cases, the observations made by the Honorable Supreme Court directly dealt with the constitutional morality, the role of the society, and what all are the basic principles to be taken into consideration while dealing with those lines.
Yes, legal positivism, for instance.
Yes.
That was interesting. Jeremy Bentham and Austin's opinion and Professor Hart's opinion against him, J.S. Mill's opinion.
Yes.
Fantastic. It was very interesting. And Sabarimala case to some extent is mixed with religion also.
Yes.
It's a bit
Article
difficult
25 and 26 was were dealt. Article 25 and 26 elaborately dealt there. That is why the verdict came on those lines.
And also the morality in Article 55, they have considered all those things. Regarding 497 IPC, really Kautilya would agree with it.
Yes.
Definitely. You should read his section on divorce.
Yes.
There is no real word as divorce in any of the Indian texts.
Ancient texts.
But he says moksha from marriage, release from marriage.
Yes.
There he says the individual woman should enforce a right to have the marital life or not, and where she could get release.
Yes.
But the condition he lays is that if the life of any of the partner is at stake, then you take release, not otherwise. Whereas all the other people, they have been much more liberal. They say if the husband is blind, if the husband is leper, if the husband has gone out and is not traceable, if he has become a sannyasi or something, the woman can remarry at any stage of her life, even though she may have grown up children. That much of liberty they have given where remarriage is concerned. But Kautilya is very, very cautious on that. He says, unless and until your life is at stake, you cannot do that.
Yes.
So there he is very strict also. Just as he has done on other moral issues, he is doing this also here. He says, your life, if your life is at stake, you can divorce, not otherwise. So it is very interesting, all these ideas. We do have the seeds of all these things in our Dharma Shastras.
Yes.
Actually, we are now having a chair instituted for the specific purpose of understanding law and jurisprudence in Sanatana Dharma.
Yes.
So Professor Tyagarajan is appointed, retired professor of Sanskrit from Presidency College, is appointed for that. He'll be working on it.
Yes.
And it is wonderful to understand the modern law, because we are far removed from you people. We do not know what it is unless what we see in the paper.
Yes.
Well, we deal with our works, so we are very familiar with it.
Yes.
And I'm proud to say that we did a PhD on women's legal rights in Sanskrit Dharma Shastras. And it was very much appreciated.
Yes.
Then only we came to know that
according to me, those shastras to be brought in practice. Otherwise, the societies, the present, the root, shape.
At least in India, where the system still lives in a way or the other.
Necessarily,
Majakani Chottu, it lives in a way.
Correct.
Though your people have given equal rights to man and woman, Manjakani is not touched by any man.
Correct.
It could not be touched. It is given from one woman to another woman.
Yes.
which has got, the man has got no right to touch it at all.
Correct.
There you have not asked about equality there.
Yes.
Why the woman has got the equality for the rights of the father,
Yes.
you cannot touch the Manjagani. So there are some nuances which are really very, very, very positive for the female
Yes.
and negative for the male.
Yes.
But the male is given more power.
That is why one of the famous and eminent Indian jurist K.P. Jaiswal said, the Hindu system of law has been so rich in principles.
Yes, in
Precedents
principles.
and,
Yes, yes.
and concepts that even the most advanced legal system of modern times are unable to surpass it.
Exactly, exactly. That's what we also find in many times. Only thing is we have to reinterpret them and
Correct.
put them in a way to for the modern jurisprudence to take it into its stride and then go ahead.
Yes.
It's very interesting, sir. Very interesting. I will invite Dr. Srinivasan. Is he there? Dr. Srinivasan? Balu? Balasubramaniam?
Yeah.
Yes, Srinivasan there. Has he got any comments? Anything to add, Professor Tyagarajan? I am able to see. Hello.
In the system, some problem in audio as well as video system.
Yeah.
Yes, exactly. Some people are not getting the lines. Yes, sir. We are. Your line is breaking. We are not seeing you. We are able to hear you.
Dr. Srinivasan is also here.
Yeah. Do you see him? I don't see him.
No, he has hidden himself.
Yes.
It is like what is called carrying coal to Newcastle. And
True.
like me speaking on this particular thing. But anyway, as she has invited, I would like to just give only two of my observations regarding this particular act of law. As she has quoted Kautilya and all the Dharmasastrakaras, they have specifically said 4 pramanas: Shruti, Smriti, Achara, and Rajagya, the current edicts of the king of the current period. The 4 are considered to be the pramana for the legal aspect, law or enforcement of law or whatever it may be. But which one is really superior? Which one overrides other? Where there is a contradiction between two, which has to be enforced. That also becomes a problem. What the traditional people are, as he says, the traditional moralists, etc., they will hold Shruti will be the most superior, and then Smriti is less than that. When there is a conflict between Shruti and Smriti, Shruti will hold good and Smriti has to yield to it. But when the current law, etc., are based on, current law means the current law in those days, when the law is framed, they are based on Achara. Because what Achara Prabhu Dharmaha, even in Vishnu Sahasranama, we have this Sarvagamanam Achara Pratamam Parikalpate Achara Prabhu Dharmaha. So the basic jurisprudence principle in those days was the current Achara, Shruti is written or no doubt about it, Smriti also is there, but many of the things, as they say, that is even in all the religious texts, it is there. That is all the religion, not only Hindu religion, other religions also. The current practices are the practices which are there, which might not have been recorded.
In the earlier times.
They become Achara and they become enforceable. And but Achara becomes nebulous, so the Rajagya becomes very important. And as far as Kautilya, the problem is which one will hold good when where. So there were always discussion. Should Rajagya, they have not taken all the 4 as in that particular order. They have taken relatively. The discussions were there, and that particular discussion reminds me of the current, the constitutional morality and the legal morality and things like that. Which one holds good? Sometimes, say in 18th century, etc., the social morality might have held good, and then slowly with the evolution of constitution, with the evolution of law, etc., one thing will be giving room for, or even among the 3 pillars. For example, say the during 1970s, the edicts of the legislature might have held they might have even what is called the fundamental laws gave room for edicts of the law, like that. These are all evolving principles, understanding principles. The power play also, I think, in my opinion, power play also has got its own way. That also may come into the picture. That is one thing. So this sort of discussion, this sort of things, the evolutions and trying to ascertain, that is going on from time immemorial. I think so. I don't know. I should
You're
not.
right. You're right.
In that connection, I'll ask Justice one question. Does
I
the,
will
that,
have-
that,
I
that,
have-
do the
I have
do the
only,
political
I think I should not be mistaken. It is a doubt. I don't know. The doubt is always there. Whether I can express my doubt or not, I don't know. In the case of Satyamala, it is not the question of whether ladies are allowed or not, etc. That is entirely different thing. But this is a transcendental matter where it is pertaining to religion, pertaining to our moksha, pertaining to our emancipation, evolution, and all those things. And it is essentially a discussion based on our faith, trust. Say, for example, initially it starts with faith. But unless I have a trust and confidence in my religion, even my personal belief in me, what is going to be my future, not only in this life, not only in this world, but in future life, what am I going to be, what will be this sort of fear, and that sort of fear may give psychological problems, and the society also may have its own existential problems because it is a transcendental matter. So, can we have this sort of purely technical legal principles, etc., totally inspiring or overriding? That where we have to draw our Lakshman Rekha. I mean, it is only for understanding. I can't, because in the as you say, in the case of the public good, in the case of the good of the so many people, and that cannot be what is called a majoritarian concern. That cannot be, in the case of good, it cannot be voted by majority, it cannot be voted by like that. It should be purely based on constitutional principles, etc., which alone, that is, logic is more important than emotion. So we cannot have certain, we cannot take certain situations, certain decisions based on things like that. That's what Kautilya also says. Blah blah. It stops there. I can't develop it further.
Do you want an answer from the justice? No, it's only your comment.
Yes.
Good.
So, thank you very much for this extraordinary opportunity. And I once again thank Justice Prabhas Sridevan, who invited me long back and periodically also insisted for this kind of lecture. Thank you very much, Justice. And I thank the Secretary as well as the other eminent personalities who joined together in this evening for this speech.
Yeah, actually, I had a doubt, but my
Please ask him.
Your Lordship is an encyclopedia on our ancient.
Srinath, we are not able to hear you. Your voice.
Is it?
Your voice is not audible.
Hello.
I think some...
Yes.
Am I audible now?
Yes.
Yes.
The concept of aram, is it similar to constitutional morality?
No, aram can be defined in various aspects. It cannot be simply said that it can be equated with constitutional morality alone. That is our pride.
It is like dharma.
Dharma.
The concept of dharma is not single thing.
Yes.
Comprised of so many other things. The same is aram.
Yes.
You cannot equate it with constitutional morality. Societal morality also comes. Individual morality also comes. Individual righteousness, everything comes there.
It cannot be interpreted as usual in the social sense.
Yes. Thank you, sir, for a nice evening.
Thank you.
We had really a good informative lecture. And
you.
we really appreciate it. And we will be able to see our own Dharma Shastras from your perspective, so that we understand it better and put it forward.
That is our Dharma Shastra. What I projected in this evening is only on the basis of the decided cases.
You are right. You are right. You are right.
What I say.
I thank everybody who participated today and the family of Professor Mr. Raghunathan IAS. I think Shyamla Mami and Daya Nadamuni, probably they are not on the line today because of their time difference. So they will be hearing it after in YouTube and come back to us. I think Mommy will appreciate it very much.
All right.
She had actually grown with Mr.
Enjoy our tradition, when we enjoy our tradition, when we read all extraordinary Sanskrit scripts as well as Tamil scripts, we are always top in the world. There is no
Yes.
difficulty to understand. Even in
Yes.
one of the Alvar Pasaram, it says, when he describes Peruman, Tane Tanakoman Tanuruve Yovurum, Tane Tavum Taragayum, Tane Yentisayum Andati Iru Tisayum Anai. This concept cannot be equated by any of the religions in the world.
Yes, true.
So our
Yes.
Dharma Shastra, our the greatest philosophers created a lot. But the present scenario, when we talk about the courts and the constitution and the laws, where we are going now? So that is to be discussed, that is to be brought in, and even the younger generation must be educated on those lines.
Yes, I think so.
What I
Yes.
expected here.
Exactly. Thank you, sir, for the
Thank you, madam. Thank you very much.
Concluding ideas. Thank you very much.
Thank you very much.
We will close for today, and then the next meeting will be announced soon, probably on the 12th. We'll have one lecture by Dr. Sita Sundararaman on Asthana Kolaghanam, a Tamil mathematical text.
Oh,
I invite the justice to participate and enjoy.
definitely.
Thank you, sir.
Thank you very much. Thank you very much.
Thank you very much, sir.
Thank you very much, madam. Thank you, Judge. Thank you very much.
Thank you very much.
Thank you. Right from the Erode meeting, right from the Erode meeting, I was waiting for this opportunity, and ultimately I got it.
Yes.
That is very nice. Thank you.
Thank you very much.
Thank you.
Thank you. Thank you.